12th October 2005, the country got the Right to Information Act. It was also coincidentally Dussehra that day, which is a festival that celebrates the victory of good over evil. And this law was definitely seen as a victory of the civil society and all of the general public. Because so far, the corridors of power had been very opaque and inaccessible, but this law came with the promise of bringing in more transparency in governance. And this is exactly the law that we'll be talking about in today's episode of Laws of the Land. For this episode, you have me, Apoorva Mandhani, you have Bhadra, Sinha, who you've often seen on our videos, and we have with us Anjali Bhardwaj to tell you a bit about Anjali and why she's the perfect person to talk about this law to you. She is a co-convener of the National Campaign for People's Right to Information and is also the founding partner of Satark Nagrik Sangathan. Most importantly, Anjali has also been involved with the Right to Information movement since the 1990s. So she's seen the grassroots movement behind the law, which is very fascinating, and we'll be talking more about that, of course. And she's also seen, of course, how the law has evolved over the years. Thank you so much for being with us, Anjali.
Pleasure. Yeah. So, I would also like to extend a very warm welcome because, I've seen you often running around in the court corridors, fighting for this law and effective implementation of this law. But to start with, as Apoorva mentioned in the introduction, that, there was a grassroots movement that actually led to the formulation of this law. But we all know, that the genesis of this law actually lies in a very, in a very popular judgment delivered by the Supreme Court in 1976, where the Supreme Court held that right to information is actually an integral right part of Article 19. So for our viewers, could you just explain in brief the judgment and then how the grassroots movement actually began?
Well, it is true that there were several judicial pronouncements. Of course, there was the Rajnarayan judgment, there was the S.P. Gupta judgment, many of which very clearly stated that the right to information is a right of the citizens in a democracy. They have a right to know what the government of the day is doing on their behalf. And they very clearly said that the right to information flows from the Constitution, Article 19, 1A of the Constitution and Article 21 of the Constitution. So when we say that people have the right to free speech and expression in Article 19, 1A, basically the court said that you can't essentially express yourself freely unless you have information, unless you're informed. And without information in a democracy, people's right to life is not, they cannot realize their right to life with dignity. And we did see that despite the court's pronouncements, it wasn't easy for citizens to be able to realize this right. And therefore, there was a need, a felt need by citizens across the country for a proper mechanism and a process by which they could access information that they should have. And there was a very strong popular demand and a popular movement that demanded the passage of a right to information law. In 2005, the national RTI law was passed, but even before that, there were 9 states that enacted right to information laws. And people used these laws, even though they were not perfect, but they provided them a window of the kind of information that they could get. And therefore, there were people, this movement which demanded the right to information law nationally grew in numbers. There were people who, of course, belonged to different socio-economic strata. So there were academics, there were lawyers, but also there were peasants, there were workers living in slum settlements in places like Delhi, in villages of Rajasthan and other states, who realized that without information, they can't really hold the government accountable. And in 2005, finally, we got a law which came as a result of a strong movement and a lot of engagement, even in the drafting of the law by civil society. And therefore, if we look at even the international rankings, we see that India's RTI law has always ranked amongst the top 10 in the world. But I would say that even more significant is the use of the law. Because the law, people feel that they own this law, and it really addresses the problems that they used to face in accessing information. It's been used very vibrantly by people across the country.
What actually nudged the government to finally bring in this law? Since you were part of the, the grassroots level movement and also engaged with the government at various levels. So, of course, there must have been opposition. As you said, there were several judgments, but there was still reluctance on the part of the government to bring this law. But finally, what really nudged the government to bring the law?
I think there are always windows of opportunity, and I think we found, the movement found that window of opportunity when finally the right to information, a guarantee of a proper right to information law, a strong right to information law, was included in the Common Minimum Program before the 2004 elections. And perhaps there was also a need to show that there was a commitment to fighting corruption. And when the NSC was finally formed, there were people who found a place, and the movement found a voice there as well. And the law was brought in 2005. Even before that, a freedom of information law was passed in 2002. Unfortunately, that law was never operationalized.
I see.
So finally, in 2005, when the RTI law was passed, the freedom of information law, which was a much weaker legislation, it was repealed, and the RTI law became a statute.
So what kind of information can the public actually access through RTI?
Well, the right to information law as it exists today gives people the right to access all kinds of information from the government, because the basic spirit of the right to information law is that in a democracy, when we say democracy, government is of, by, and for the people, then essentially the government is holding information on behalf of citizens. And therefore, the law very clearly defines information as any kind of information in any form that is held by the government. And there is a list of exemptions, of course, as there should be, because there is some information that cannot be made public. Information, for example, that would adversely impact, let's say, the economic security of the country or the sovereignty of the country, information that's expressly forbidden by the courts for certain reasons. Information that would cause unwarranted invasion of anyone's privacy. I remember when the law was being drafted, one of the groups that did express its reservations was a group that worked with HIV positive patients. So they said that there is such a stigma attached to some of this information if it goes in the public domain for people who suffer from, who are HIV positive, that if all the information starts going out, it would cause unwarranted invasion of their privacy. So the law has very strong provisions to ensure, but they're very tightly worded as well, so that they're not misused, to ensure that certain kinds of information is not given out. But apart from that, all information that is held by the government is in fact accessible to people. In addition to that, since you asked what all is available, this is something that many of us don't realize, but the law provides that any information, even about a private entity, that can be accessed by the government under any law for the time being in force, can also be accessed by citizens. Now, this essentially means that even for private entities, although we cannot file right to information applications directly to them, but in most cases where public interest is involved, if we want information, if there is a law that provides for the government to access that information from a private entity, it can also be accessed by citizens.
My next question was going to be that only, that when you talk about government, I mean, what are the kind of authorities that actually get covered under this definition or this umbrella called the government?
So there is a very clear definition of a public authority, and so the law basically says that it applies to all public authorities, and in that it's any body that is set up by the government. It's it's set up under the Constitution. It's set up by a state or a central government. So the law actually applies to all tiers of government. It applies to the executive, it applies to the legislature, and it also applies to the judiciary,
Right.
which is not true of all information access laws across the world. So our law covers a very wide ambit in that, and also non-government organizations that are substantially financed by public money, by the government. Because the logic is that as a citizen, I pay taxes. So if my money, government money, is being spent anywhere, I have a right to know how it is being spent and on what. And therefore, even organizations that might not be set up as government bodies, as public sector units, if they are substantially financed by the government, they are covered, and we have a right to access information about them.
Since you mentioned that there were concerns raised at that time by people who were HIV positive about their privacy, is there a sort of struggle that's often seen? It was seen back then. Is it still seen between the right to privacy and the right to information? How does the law ensure a sort of a balance to ensure both the rights?
Right. So I think it's widely understood that both the right to information and the right to privacy are important for people to lead a life of dignity. I mean, we do want the right to information, but there should not be, any kind of infringement on any of our right to privacy. Surveillance, undue sort of interference and collection of information or dissemination of it about people, which is not warranted, must not happen.
Right.
But yes, you're right that there is sometimes a balance that we need to strike between the right to information and the right to privacy. And the Right to Information Act, which was passed in 2005, actually recognizes the need to bring in that balance. And Section 81J of the Right to Information Act clearly states that personal information which has no relation to any public activity or interest cannot be accessed, and personal information which would cause unwarranted invasion of an individual's privacy cannot be accessed under the RTI law unless there is a larger public interest that warrants the disclosure of that information. So there is a balance that the law very clearly builds in to its very structure to prevent any kind of violation of anyone's privacy.
Now, the law currently has that balance, of course, but since you mentioned Section 81J, the Personal Data Protection Bill intends on bringing about an amendment to the provision. Could you tell our viewers a little bit about that, and also about the concerns raised about the balance that we just spoke about, that this amendment might sort of screw the balance to one or the other side?
Yeah. So let me, if I may, let me actually say that what is the kind of information, especially personal information, that people find important to access. So for example, when we talk about the use of the right to information law, especially by the most marginalized and by people who are seeking accountability of the state, one very important thing that people have understood in the last 17 years since the RTI law has come is that unless people have information, they are unable to access their rights and entitlements that are due to them. So I remember that we work in the slum settlements in Delhi. When the right to information law was passed, I went and told people that, in the bastis, that there is this fabulous law, you must use it. And one of the women in the basti stood up and said, we don't even get our rations. What are we going to do with information? And we realized that people want information not for the sake of information, but if they are able to actually hold the state accountable and get their rights and entitlements. So the first set, amongst the first set of RTI applications that was filed, was to ask for ration records of the various ration shops in that area. And what people asked for was the list of beneficiaries who are supposed to get rations, asked for the stock registers of the shops and for the sale registers, which show who got how much rations. And on the basis of that, when they got that information, they were able to establish large-scale corruption because their ration cards showed that they weren't getting rations or they were getting very little rations. Whereas the records showed for family after family that they were being denied. So a public hearing was organized where people collectively discussed those records, and it forced the government to take action. And from a place where nobody ever got ration or never got their full entitlement, everyone started getting their rations on time. Now that is really what is the power of information for a common person in our country.
Right.
Now, when we say that, the Section 8(1)(j, and you talked about the Data Protection Bill, the Data Protection Bill in its current form, which has been put out by MeitY at the moment, that basically amends the Right to Information law and says that any personal information will be exempt from disclosure. Now, this would essentially imply that all this kind of information, whether it is about rations or it is about another scheme or law like pensions or let's say scholarships that children are supposed to get, all of that information people will not be able to publicly access. Right. Now, we know that unless there is public monitoring and involvement of citizens, there is corruption. And, when we say that information is the best disinfectant, transparency is the best disinfectant, it is the best tool to fight corruption and empower citizens. And we see that, when I was saying that the Indian RTI law is vibrant, I want to add here that it's also the most vibrant use of the RTI law that we see in our country. So we have about 60 lakh people, so about 6 million people filing RTI applications every year to access information. It's the largest globally. And a lot of them are asking for information so that there can be public monitoring, there can be social audits. For all of that, if the law is amended the way the Data Protection Bill envisages it, all of this public monitoring would stop, and it would provide a very, very fertile ground for corruption to exist. And that is a big concern because people not only want information about their own entitlements in these cases, but they want information at a larger scale so that there can be public monitoring.
So let's talk about how the law has actually fared on the ground. You just spoke about the law being vibrant and roughly around 6 million applications being filed every year across the country. How many of them actually get a government response and how many of them are rejected and on what grounds?
So, it's very difficult to say the exact numbers, but our research has shown that in about 50% of the cases, people do actually get a response and get the information that they're seeking, which is a huge improvement on the pre-RTI days where somebody would just go into to a public authority and they would be given a runaround and they would be told, this is not the office, please go to the next office, and they would spend days and get frustrated and not get the information. So the law actually is enabling a very large number of people to access information that they want. But it is also true that there is a lot of resistance amongst public authorities to share information, especially when it is sensitive information which would either expose the government's, let's say corruption that's happening, that would expose vested interests, or where there is information that's inconvenient for a public authority to give. So there are a very large number of cases, nearly 50%, where people don't get the information that they're seeking. Under the law, there is an appellate process that has been given. So there is a first appeal which is within the department, which very often is not successful. But the law also provides for a second appeal, which is with the information commissions. And these are bodies which are empowered, and they're supposed to act independently of the government and make sure that if under the law, people are supposed to get information, they can direct the governments and the public authorities to provide that information to them. They also have the powers to impose penalties. So their orders are taken seriously. And we see that a large number of cases, first appeals are filed. A few cases, second appeals are filed, but people are successful in accessing that information. I would say that if we look at the use of the law, it's been used and people have successfully accessed information about their basic rights, like on rations, on pensions, on water, medicines in hospitals, and the number of teachers that are coming to teach in a government school. But also at the highest levels, they've been able to access information about the functioning of the government and about the conduct of public servants. So we've had information being sought about the working of political parties, for example. And when political parties did not share information with citizens, the case went up to the Central Information Commission, and the commission said, yes, political parties are substantially financed by public money. And also they play a very important public role, and therefore there's a public interest in them being under the ambit of the RTI law. So the Central Information Commission said that 6 national parties that were, the case that was being agitated, they said they are public authorities under the law. Similarly, people have asked for assets and liabilities of Supreme Court judges, of High Court judges, of senior officials and public servants. People have also asked for information about the educational qualifications of many public servants. So this is something that people have used the right to information law, and also very effectively to expose large-scale corruption. I'm hard-pressed to think of any large scam that has come out in the last 17 years where the right to information law has not been used, whether it is the Adarsh scam or the Vyapam scam or the 2G scam. We have people using the RTI law to access records, which then shows corruption. So it's something that is being used by every movement in the country, whether it is the environment movement or it is electoral reform movement, where people are saying, why should electoral bonds be opaque? Why should we not have information about who's funding political parties and how much? So the law is being used very vibrantly because people have understood that if they are to really engage meaningfully in a democracy in governance, they need to have information.
So the 50% rejection, what is the primary reason for rejecting such applications?
There are several reasons. One of the main reasons is the use of Section 81J, where there is a plea that because of privacy, information cannot be provided to citizens. There is also the use of the exemption clause, which says that this might harm national security or national interests. We see that some of these rejections or denials are legitimate, but a very large percentage of them are, they don't really, they cannot be termed legitimate. They're not legal. And in many cases, public information officers don't even give reasons in terms of exemptions. They just do a blanket denial. It's not even a speaking order. So they just say, we don't give you the information, we deny it to you. And all of these are very problematic because these, in a sense, are a violation of people's right to information.
So I have a question to ask you, is that which of the 3 wings you think is the most reluctant to giving out information under the RTI, the executive, judiciary, or the legislative?
I think globally, anybody who has to share information is reluctant to give information because it is always easier to work behind a veil of secrecy. And in our country, we've had a very long tradition of working behind a veil of secrecy where people were not involved in decision making in a real sense because they were not always able to access the information that they needed. They were not able to monitor government in the sense that they should in a democracy. And therefore, there is a very long tradition of all public authorities of not sharing information. So when the right to information law has come, it's almost, an act of revolution.
That's
where,
right.
where people, we've heard so many public information officers say, how is this person just walking in and asking for, can you just ask for any information under the sun? Why am I answerable to this person? How does this person even understand what I'm doing? So, there is a lot of reluctance, but because there is a law and with very, very clearly defined obligations, we've had a very good success rate of seeking information. But since you asked, I will say that yes, there are many cases, especially where there are human rights violations and corruption involved, where the executive refuses to share information. Unfortunately, increasingly, we are seeing systems that are being put in place where, public authorities are set up very clearly saying, but they will not come under the ambit of the RTI law. Yeah. So whether you look at electoral bonds, for example, the entire scheme, it's been clearly said in the inception of the scheme and while amending the laws to bring about that scheme, that information will not be provided to citizens. The PM Cares Fund, for example.
It was kept out of the ambit of the RTI.
Kept out of the ambit of the RTI law. Now, people have a problem because they want to know all this information. There's great public interest in knowing where this money is coming from to political parties because finally there is quid pro quo.
True.
So citizens want to know that when I go to vote, I want to know which party is getting money from whom.
Where, yeah.
And that is where I can imagine the party's policies will kind of, and laws that they make if they come to power will be, they're going to work for those people who are funding them.
In fact, if you recollect a Supreme Court judgment on knowing, on a citizen's right to know his or her candidate, very clearly says that unless you're informed about a candidate, you cannot make a choice.
Absolutely.
About the candidate, his background or her background. So it's very important to be informed about who you are voting for. So if it is applicable to a candidate, then it is equally and rightly applicable to a political party as well.
Absolutely. And in a country like ours, where very often people vote for parties, even more than looking at a candidate, individual candidate, it's very important for people to know what the party is doing, how they're taking decisions, and very importantly, where they're getting the money from. So that is a very big problem today. But I would say that also the judiciary, where, we saw these fantastic judicial pronouncements, which in many senses led to the enactment of the right to information law, finally in 2005. We see that under the law now, since the judiciary is also covered, when people are asking for information from the judiciary about its own functioning, we are seeing that there isn't that kind of enthusiasm to give information. And many cases we've seen where information, it would seem very logical and reasonable to provide information. Information has been denied. Those cases have had to go through years of the appellate process, including within the judiciary. Before information is given out. So there is a reluctance, and unfortunately we've also seen that after the law has been passed, there have been certain judgments where the right to information law has been restricted, which are concerning. But yes, even in the judiciary there have been several steps that have been taken. The more recent step of live streaming the proceedings of the hearings of the court, especially in the constitutional matters. So all of this is important, and we hope very much that as time passes and this law kind of gets more ingrained in our system of governance and democracy, there will be less resistance, and people, like we see in many countries in the world where we really think governance is working well and democracy is working well, whether it's the Scandinavian countries or other countries, where transparency is really built into systems.
Right.
And under the RTI law, there is a provision of under section 4 of proactive disclosure by public authorities. And that's very important in a country like ours, where a very large set of people are unlettered, find it very difficult to file RTI applications and follow it up, but need information.
Right.
So there is an obligation on public authorities to themselves give out information in the most accessible way in local language to people.
Right.
Unfortunately, the implementation of that has been
not really,
very poor so
it's
far
very
in most
ineffective,
public authorities. And we can only hope that with time this is going to improve. And especially if there are governments that say that they want to fight corruption, they want to be more transparent and accountable, then this is one area that needs very, very significant working on.
Since you mentioned in implementation, we've often seen this gap between the law and the substantive provisions of the law and how they're implemented on the ground. Especially, since we've been doing this show, all the laws that we've taken up, that's one thing that has been sort of common over all the laws, that even if the intention behind the law and the law itself was revolutionary when it was brought in, but on the ground there isn't either there aren't enough resources, or there isn't enough acceptance from the authorities or from the stakeholders. In this case, for example, if we talk about information commissions, are they equipped enough to handle this vibrant usage of the law?
Yeah, I think this is a very, very important area because, you see, in our country, if there is a violation of a right, we can, of course, approach the courts. But we know how cumbersome that process can be, especially for people who sort of need information on a day-to-day basis to be able to access their other rights. Therefore, under the law, there is this independent information commission as an institution that has been set up to make sure that if there is any violation of the law, citizens can approach the commission in an appeal or a complaint. And because the commissions have these powers of imposing penalties, granting compensation, they have the power to direct governments to give information.
Right.
Now, therefore, it makes the commissions a very, very key and pivotal part of the operationalization of this law. Unfortunately, just as citizens, we have understood how important commissions are. The government has also been very quick to understand how important commissions are for the functioning of this law. And this is not any one government. Unfortunately, this is governments across the country. So if we look at, we bring out the report cards on information commissions where we file RTI applications and ask the commissions for information which we compile. We look at how many commissioners are there in each commission.
Right.
And if we look at the status of the commissions in the country, it's really very, very alarming in many cases. So if you look at states like Jharkhand and Tripura, there is no information commissioner at all in the commission. Which means that if in the state of Jharkhand, anybody, any tribal, any other person wants information, and it's critical for them to be able to realize their constitutional rights, if they don't get that information, they don't have an appellate process under the RTI law. So it's a very fundamental violation of their right to information. And yet, despite repeatedly being told, civil society asking and the court telling the government to appoint information commissioners, it has not been done. The Central Information Commission, since 2014, not a single information commissioner has been appointed to the CIC, the Central Information Commission, unless people have approached the courts. It's a record. And this just shows that there is very little political will to make sure that people are informed, are able to exercise the right to information. And another thing which I think is very important here is that governments have realized that there is no way to stop people from asking for information. There have been nearly 100 people who've been killed in India simply for filing RTI applications, accessing information and using it to fight corruption.
Right.
And yet people don't stop asking for information. There's so many who are threatened. People still understand the power of information and keep going at it. So the governments have realized that there is no way for them to stop this decentralized use of the RTI law. The best way for them is to actually clip the wings at a centralized level, which is the institution of the commissions. And therefore, they feel that if they don't appoint commissioners, then people will not get information that the government doesn't want them to have. Also, where appointments are made, unfortunately, in a lot of cases, and many of these cases have been agitated in various courts, the appointments are made of only people who are pliable, who have been ex-bureaucrats, who are willing to toe the government line. And therefore, there has been a huge push to say that the process of appointment of information commissioners itself must be transparent. It must not be arbitrary. So that the right kind of people, without too much government interference, can be made information commissioners. We've had ex-directors of the IB, the Intelligence Bureau, who have been made the chief information commissioners of the country. So, there is a way, this is a way to actually control the flow of information to our mind. And because there are not enough information commissioners that are appointed, and also at times not the right kind of people who are appointed, we are seeing that there is a very large number of pending appeals and complaints in commissions. So our reports have shown that there are more than 3 lakh cases that are pending. The backlog is 3 lakh cases in all the commissions in the country, which means that people have to wait for a long period of time to get their cases heard. So you can imagine that if there is an old woman who's not getting her pension and she has to wait for a few years for her case to be heard by the commission because she doesn't get the information that she sought, very often by the time the information comes, she's, it's of no use to her. And therefore, in many senses, information delayed is information denied. And we are seeing that in a state like West Bengal, we calculated the estimated time for a hearing for an appeal or complaint in the West Bengal Information Commission is more than 24 years.
Oh my God.
In Odisha, it's more than 5 years. So, this is a very, very effective way of making the right to information law ineffective for citizens.
As per your report card, which state has actually fared extremely well and would top the list when it comes to implementation of RTI Act?
So what we do really is to compile the information and put it out in the form of a report card. I would say that there are some commissions that have done very, very well in terms of the number of cases that are being disposed. There are, like Uttar Pradesh has amongst the highest rates of disposal by the commissioners. And also they have almost a full complement of commissioners that have been appointed. Maharashtra at this moment has a large number of cases being disposed, but out of 11 commissioners that can be appointed, the Maharashtra state government has not appointed 6 commissioners. So in Maharashtra, there is a backlog of 1 lakh cases. So you can imagine how long it will take for a case to come up. In Punjab, in Haryana, the number of penalties that are imposed is very significant. And the Commission is doing very well on sending out a signal to the public information officers that if you do not perform and do not give information to people, you will be penalized. There will be consequences. So there are different parameters on which different state commissions are doing well. And like I said, that there are states where there are just no commissioners appointed, or there are such few commissioners appointed that, we just don't see the kind of disposal that is required for people to realize their right to information.
Right. So there is hope. We do have a few states that are doing really well. With this, we've reached the end of this episode. We've discussed how the law is revolutionary. It's vibrant in its use. There are things that can be definitely made better on the ground. There are ways in which, like ma'am mentioned, the wings of the law are being clipped in a manner, but people are still pushing back. We are still demanding for information. And since this entire law began with a grassroots movement, it was law for the people. It is the people who are still demanding this information and will keep demanding it. Thank you so much for joining us, ma'am. It was wonderful having this conversation. I hope you enjoyed this conversation as well as we enjoyed having it. Please do let us know in the comments section and keep following us the way you do.